And I hope everyone can see that. And if you can't, then someone will yell at me, I am sure, and tell me they can't see it. Sorry, get my screen organized here. So the title of this class, when you looked at it at the Cedars Union, was licensing, but the longer title is licensing, contracts, and agreements. And part of the reason we talk about that is a license is simply a type of contract. It's a type of an agreement. And so we're going to spend just a little bit of time at the top talking about what is a contract and what do we have to worry about, what makes a valid contract. And then we're going to get into the subtype of contract that is the topic of today, licenses and how they apply to artists. Now, let me say right at the outset, a lot of the language that you see that I'm going to show is photography related. That's my background, and my current position is spent writing licenses for photographers all the time. But you just put in whatever medium you work in, because a license is simply a giving someone permission to use a piece of property that you own with certain conditions, right? And so it could be a painting or photograph or sculpture or anything that you have, film or video. And so if you hear me talk about photographs or photography, you see it written, just replace that with whatever you do. I'm not going to read the whole long disclaimer that we've been writing, but of course, Michael and I are lawyers. You always want to check with your attorney and your accountant before relying on information that we might talk about today. Contracts are legal documents, right? And when you sign your name to it, you're binding yourself to whatever's in it. It's my hope that we can give you some good information, but you really don't want to rely on it specifically when you're negotiating your next deal. You really want to have some people on your team. And I always talk about, finding an accountant, finding an attorney. And those are some questions that we can talk about as well. So contracts, agreements, licenses, legal documents, all of this feels complex, right? A lot of times when I talk with artists, they're like, well, no, I don't have a contract. I just have some emails back and forth that talk about what we're doing. Well, that's a contract, right? Everything really is a contract. When you go to the store and you buy something and you give them money and they give you a product, that's a contract. You've entered into a contractual relationship, right? Now, of course, we think of contracts as these big, incredibly long things that, everyone has to sign and date, but contracts don't have to be that. They can be emails. They can be series of text messages. They don't even have to be written at all in most cases. And we're going to go into the different parts of a contract, but what I want you to remember at the outset is that everything's a contract. One thing that I talk about in some of the classes that I give, but I think it's important when we're talking in this type of class, is that you are artists, but you're businesses, right? And if you want to be able to pay your bills with your art, then you need to think of yourself as a business. And for so many artists, it's a difficult thing to wrap your head around that you just want to create the work that you want to create. But it's okay to have success, right? Your worth as an artist is not inversely proportional to any commercial success that you might have. I often also hear from artists who say things like, well, this all seems really complex, and I understand that I need a contract. I understand that I need to copyright stuff, but I don't have the money to do all of that, or whatever. And because they can't do all of it, they don't do any of it. And my recommendation would be to take some of the principles that we talk about and try to apply them to what you are currently doing, right? Thinking about the different parts of a contract requires $0. It just requires to understand a little bit more about what a contract is. So we're going to talk about what contract is. We're going to talk about licenses. We're going to talk about this idea of works made for hire because they affect licenses in a clear way. We're going to talk about drafting licenses, and then we're going to look at some actual examples of licenses that I've drafted for different clients. And we'll make this presentation available to you as well, so you can refer to it. Let's start with what is a contract. Like I said, everything's a contract, and contracts are, in the whole pantheon of legal documents and legal concepts, relatively simple, right? Contracts are an exchange of promises. I promise to do this if you promise to do that. And I always like this definition. It's an agreement between two or more parties where people agree to perform or agree to abstain from any act. It's not just that we agree to do something. You can have a contract where someone pays you not to paint something, right? Now, that would be an interesting scenario. But remember that contracts don't have to be just about doing something. They can also be about not doing something. And that actually comes into play sometimes with licenses. Why have I spent already so much time on contracts and I want to spend more time on contracts? Well, contracts protect the parties, right? And you'll often see these one-sided contracts, and one-sided contracts don't really help anyone, right? And artists are often presented with a contract. And if the contract you're presented with is super one-sided, then you want to push back in certain areas, and you might not know what those areas are. And we're going to talk about some of them today. But the purpose of a contract, in my view, more than anything else, is to clarify confusion that the parties might have about what they're supposed to be doing, or what they're going to get paid, or when they're going to get paid, or how many pieces they're supposed to create. Contracts are about clarifying confusion. I have here, contracts should be written and never seen again. And when I was in private practice, I would tell clients, look, here's this long contract and you paid me to write it, and it's many, many pages, and everyone signed it. And it's my hope that you put it in a drawer and you never look at it one more time. Because frankly, if a year from now you're going back and looking at a contract that you signed a year earlier, something's gone wrong, something bad has happened, and you're going back in to see what are my remedies, what are the things that I need to be worried about. So a good contract should clarify all the confusion, and then you put it away and you don't have to worry about it again. And then contracts answer what if questions, right? Well, what if I can't do this because of a pandemic, right? And that's where you might have heard this phrase in the past 2 years, force majeure. It was always part of contracts. It's the acts of God, things you can't control, earthquakes and floods and things like that. But many contracts didn't have a force majeure clause for pandemics. Now, I'll tell you now, they all do, pretty much. If a lawyer's writing a contract, they're including epidemics and pandemics in their list of force majeure clauses. But here's what happened, right? So let's say you were an artist and you've been commissioned to create a mural at a restaurant, and it's a lot of money, and the pandemic hits, and all of a sudden the restaurant can't be open and you can't do the work, or there's city or state mandates. And now what's going to happen? Does that mean that if you can't do the work for 2 years, you don't get paid, or do you get paid, or who worries about this stuff, right? These are the things we talk about in the contract.
So let me emphasize something about that last slide. You said that one of your bullet points was that contracts clarify something and that they should be written and never seen again. I would just emphasize that something else that you said. Y'all probably have entered into lots of contracts without even realizing it, because you can have oral contracts. And when it says contracts clarify confusion, that really applies to written contracts. So, I mean, the scenario is, what if you and a client on a handshake agree that you're going to paint a portrait of this person for $100, and they come back and say, well, we agreed it was going to be $25. Well, you had the contract, but it's not really clear. If you had written that down in advance, that's when it's clarified. So you can go out, and unfortunately here you got to see it again. But if you have something that you can see again, that is, if it's written, then you can prove to them that, yes, our agreement was clearly that you were going to pay me the $100 and not the $25.
Yeah, like Michael was saying, contracts, well, let me say it this way. Contracts have three parts, right? Offer, acceptance, and consideration. That doesn't have to be written. But if there is a dispute and it's not written, well, now we're in a situation where it's very hard to ascertain what the truth was, right? So just because a contract can technically be formed, to do the things like Michael was saying, to clarify that confusion, getting it written is the way to go. Okay, so three parts: offer, acceptance, consideration, right? And in law school, this is day one. You hear this, and then you spend the next 3 years figuring out what it all means. Now, we're not going to spend 3 years looking at it, but what is an offer? Well, it's a proposal, right? I'll paint your fence if you give me X. What is the acceptance? Well, I will give you $10, if you paint my fence, right? I accept your proposal. And then what is consideration? And consideration is the one that can get a little bit tricky. It's an exchange of value. Remember, this all is about licenses, because licenses are just a type of contract. And we're going to see how this all ties together. Now, as I mentioned, we'll make sure that everyone has a copy of this presentation. So I'm not going to go over every little point that's written here, but it is important to note that when you're making an offer in terms of what is a contract, there has to be some type of communication that creates a reasonable expectation that the person who you're offering to, that the person who's offering is willing to enter into a contract based on their offer, right? So essentially, you just have to communicate the fact that you are making an offer. Think of it like if you have a piece hanging in a gallery and there's a tag there and it says it costs $5,000, then the offer that's been communicated is, if you give me $5,000, I'll give you this piece of artwork. Now, offers have to have a certain level of definiteness. If you say, you give me some amount of money and I'll give you the artwork, well, that's really not a good contract. It's may not even be a contract at all. One question we get are advertisements contracts, right? What if you have an ad on your website or something that could be considered an ad? What if you're actually taking out an ad on Facebook or something like that for your services or for your products? Broad media communications are generally not considered offers to form contracts, but specific ones can be. And so, we often think of things like past buyers that you may have a particular mailing list for. Things that you might offer to them could be considered the beginnings of a contract. You can revoke an offer before the other person accepts it. You can say, I'll paint your fence for $10, and before they say anything, you say, no, never mind, it's going to be $20, right? So you've revoked the offer and you've made a new offer. And then we talk about things like rejection, where the other person can reject the offer. So I make an offer to do something. I say, I'll paint your house for $10, and the other person says no, or the other person may make a counteroffer. And they may say, well, I want you to paint my house, but I want you to do it for $5. And without getting into the reasons why this might come up too much, when you make a counteroffer, you're not continuing the path of the offer and the acceptance. What you're doing is you're rejecting the initial offer, and now you're making an offer to the other person. And so it is going in reverse. But no matter who makes an offer, then there's an acceptance, right? If you're going to have a contract, you have to have those three things: offer, acceptance, and consideration. And acceptance has to be an act of consent, right? And it can be done in any reasonable manner, but most of the time it's done in the manner that the offer was made in. And maybe not most, but a majority of the time, I think it's done in the manner the offer was made. But it has to be a reasonable manner. And like I said, that counteroffer, it's not an acceptance. Now, there are a few places where it might feel like a counteroffer, but it's not really a counteroffer. We talk about things like title that comes with buying an underlying piece of work, right? You know, a deed that might come with buying a house. There's some things that are implied as part of a contract that wouldn't make you asking for them a counteroffer. But most of the time, if there's a counteroffer going on, then that means that the original offer's been rejected and we start the process over. Now, as I mentioned, consideration is the one that can be a little bit tricky. And I always think of consideration like value, right? And so there has to be value. The value has to go both ways. So if I say, I'll paint your house for $10, I am getting $10. You are getting a painted house. We both have gotten value out of this contract. There's this idea of gratuitous promises. And I know Michael is a photographer. And so I might say to Michael, hey, Michael, show up at my apartment tomorrow and at 9 a.m. and I'll give you all my camera gear. And he says, that's great. I accept your offer to take all your camera gear. That's wonderful.
I will accept it right now.
That's right. That's right. And then he shows up at 9 a.m. and I answer my door and I'm like, I'm not giving you anything. He says, look, we had a contract. You offered and I accepted. We're good to go. You have to give me the thing. But there hasn't been an exchange of value, right? There's only been exchange of value in one direction. So that's a gratuitous promise. And that's not, you can't take me to court. Michael can't take me to court and say, well, he told me, we entered into a contract and he told me he was going to do this and then he didn't do it. And then there's this idea of nominal consideration, which is like, you know, I'll buy this house from you, but you have to give me $10 to make it legal, right? In most cases, nominal consideration is no consideration at all. The consideration for legal purposes kind of have to be roughly equivalent if the contract is going to be enforceable. Now, in my current position, the American Society of Media Photographers works not only with photographers, but with all visual artists. And about a month ago, we launched the ASMP Academy, where we have curriculums and all these courses and more information than you could want. We have like 25 legal templates and documents and all that kind of stuff, and it's growing all the time. But we are done talking about contracts, particularly right now. Over at the ASMP Academy, literally you can hear me talk about contracts for like 20 hours. We're not going to do that today. We're going to turn to a type of contract that is a license and a license agreement. And again, please, if you have questions, throw them into the Q&A, throw them, that's preferable. Feel free to chat, totally up to you. So what is a license, right? What is a license? It's just a type of contract. But the prerequisite to licensing a work is that you have to own the thing that you're licensing. And when we talk about art and licensing art, what we really are talking about is licensing the copyright that you hold, right? And when I teach classes on copyright, I talk about the #1 rule of copyright is that the minute you create a work, you own a copyright in that work. And you don't have to tell anyone, you don't have to do anything, you own that copyright. And so because you own that copyright, and it is a piece of what we call intellectual property, it's a piece of property, you can then do what you want with it. And what a license is essentially renting out the rights to do something with your artwork. But before you can license it, you have to make sure that you own it, okay? Now, remember, as the author of a work, and by author, we're using this in the legal sense when we talk about copyright, as the author of a work, you hold legal rights to the work, which means you are the only one that can reproduce, publicly display the work, perform the work, distribute the work, make derivative works. You're the only one that can do that. If anyone else in the world does that, they are infringing on your copyright, okay? And so what is a license? A license says, I, copyright owner, will allow you to reproduce my work with these conditions, and you're going to give me X, right? We got consideration, the offer and acceptance and all that stuff. A licensing agreement is a contract between two parties that allows one party to use the property that's created or owned by another party. The party giving the right, the artist, the creator, the author, the musician, the party giving the right is the licensor, and the party receiving the right is the licensee. All right, so we had a question come in, and I think it's an excellent question, and I'm just going to read it out. And it says, is it best to do limited licenses of, say, 1 year at a time for use, or longer periods? Seems like an annual would work best, so you can adjust the agreement as time goes on. Well, excellent. So I'm going to answer this by talking about licensing terms. And licensing terms, and you're going to see more of this when we look at the specific examples a little bit later on. But licensing terms are the pieces that go into the contract, and there are as many as you want. You can have terms about anything, right? I've worked on licensing agreements like for movies and stuff, and they can be, 100 pages long. And you can also have a licensing agreement that's 2 sentences long, right? But here are some that I think are important to have in your licenses. I think these are important ones to have. Now, this is not an exhaustive list, but first, you obviously want to have the information of who the licensor and licensee is. And then second goes to that question we just had. What is the length of the license? Is it a day? Is it a month? Is it a year? Is it 10 years? Is it perpetual? You can write licenses that have a perpetual duration. So as long as the underlying copyright is in existence, then the other person has the ability to reproduce it. We're going to look at when we might want to adjust that in a moment. As far as your direct question, is it better to do 1 year or annually? Here's what I would ask you to think about. And I will use photographers as an example, okay? A lot of photographers, the vast majority of commercial photographers, make their living off of licensing. And at any given time with their clients, they may have tens or hundreds of thousands of pictures under license with different companies. And if every year they were renegotiating the license, then all they would do is sit there and renegotiate licenses. So there are some times where a year is a perfect interval. There are some times, for example, let's say someone hires me to photograph headshots of their company, okay? Or someone hires me to paint headshots of the people so they can use them on the company's website. Well, if you go to the client and you say, every year you have to pay me for the right to use the headshots that I took for you, that client might not think that's such a great idea. That's a situation where you would probably have a very long, if not perpetual license. But there are also cases where you might have a very short license. For example, let's say that you have created work that is going to be sold at an art fair, and they're going to make t-shirts of your work, and the art fair runs for 2 weeks and the art fair is over. Well, I wouldn't want to license my work to someone for a year if it's only a 2-week duration. So the duration is based on what the purpose is. Number 3, exclusivity. You can have a license that's exclusive or non-exclusive. And exclusive means that the person who's licensing it from you is the only one who can do those things during that time frame. Non-exclusive means that you can sell that to a number of different people. In general, as an artist, you kind of want to stay on the non-exclusive side of things. But as a client, they want exclusive things. And so most of the time, exclusivity means the price will be higher for the work that's being licensed. Well, you obviously want to list what's being exchanged, what the value is. Most of the time, it's money in a license agreement. Usage terms and limitations, we're going to look at some. Alterations and modifications is a super interesting one, right? Because if I license my artwork for use for use as a poster that's going to be sold, and the person who licenses it then puts their big logo across the middle of it, and I didn't know they were going to do that, I say, well, you can't do that. This is my piece of art, right? And that's not okay. And then you go back and look at your license agreement. It has nothing in there about alterations or modifications, which means that the person who licensed it can probably do that. So if you don't want people to alter or modify your work, you should write that in there. You can also write in things like any alterations or modifications have to be approved by the artist. And sometimes you don't want to have that at all. For example, if you're taking pictures for a magazine and they want to put it on the cover, and to put on the cover, they have to put words and their masthead and all that stuff on there, that's an alteration or modification. But that would be pretty silly of you to tell them, no, you can't do that, right? Because then you're not going to be on the cover. So, but alteration and modifications, I think, are an important term. You can have geographic restrictions. And this ties in with exclusivity. So you can say, I will, and by the way, those of you who are represented by galleries or have looked at gallery agreements, you know, exclusivity is something that comes up there a lot as well. And it's the same type of idea with geographic restrictions, meaning I can license a photograph that I've taken for use by a company, and I can say you can only use it in Texas, but you're the only one who can use it in Texas. Let's say it's a hotel, right? And I say, I will sell this to no other hotels in Texas. And then I can go and write an exclusive license for Oklahoma. And I can do a third exclusive license for New Mexico, and they're all the same picture, and they're all exclusive licenses, but they have these geographic restrictions, right? Now, there are lots of times where exclusivity and geographic restrictions tie together. A lot of times what you'll see is, especially if you're doing commercial stuff, North America only, North America and Europe only, right? Those are the type of geographic restrictions we see in licenses. Assignments and transfers. Is the person who's licensing the work allowed to transfer that license or assign that license to someone else? This came up just the other day in a case I was looking at. A photographer did some work for a supermarket chain. That local supermarket chain was then purchased by Walmart. Now the question is, did the photos that he took for and licensed to the small supermarket chain, now that they're owned by Walmart, does Walmart have the right to take those photos and use them on their national billboards, right? So that's an interesting question. And those type of things can be answered in a clause that talks about assignments and transfers. Termination provisions are just how you end the license relationship. And those are always important. And then of course you want to have signatures. Now I listed 10 things, but as Michael will tell you, there can be hundreds of things, or there can be just a few things. Michael, yeah,
there could be hundreds of things, yes. And I don't know if you're coming back to talk about some more specific about these, but I could talk a little bit about what, if you, the artist, and somebody has come to you with a license, somebody comes to you and they want to use your image on products, or they want to use it somehow. And typically what, in my experience, happens is that they're the ones that come to you with the license agreement that they want you to sign. You did not prepare it. And they're just, yeah, and Tom, if you're going to be talking about this, tell me and I'll wait. But there are a couple of things that you can expect to see that you should be aware of and that you should be worried about and not want.
No, go for it. Go for it. And we'll jump back to the presentation. Yeah.
So one of those is that you see quite often that they're in that kind of agreement, they might have a subheading of a term that says transfer of rights. If you see the word transfer of rights in an agreement that they want you to sign, scratch that out right away. Because if you sign an agreement that is transferring your copyrights, you don't have them anymore. You want the agreement to say grant of rights. If it's a grant of rights, you are giving them something, but you are keeping the underlying copyright. If you transfer it, and this has happened to people, they transfer the copyrights. If you transfer your copyright to this company, then you cannot make that image yourself anymore. It's not your copyright, and you're not even allowed to make it. Also, I would be worried, Tom talked about exclusive versus non-exclusive rights. One thing to worry about is to look at the language. If you give somebody the exclusive right to do something, that means you might be giving up the right to do that thing. So if you are giving somebody the exclusive right to use an image on t-shirts, maybe that's fine with you, but that means you are not allowed to, you can't even yourself put that image, your image on a t-shirt. The other thing, there are a couple of things that he talked about. The scope, most of these things are going to try to be as broad as possible. They want worldwide rights to be able to do whatever they want. You want it to be as limited as possible. You want them to only have the rights to do this in Texas or in Dallas or whatever, or in North America. But they're typically the agreement that they're asking you to sign is much broader than you want. And I think I would also, it's not necessary, but I think that I would also want to include a provision that says wherever they put your image, there should be a copyright notice. Because even if you don't have that, you still have the copyright. But I think that it helps your case if you require them to tell people, even though they're using it, you are the copyright owner.
I think those are excellent points, and I'm going to touch on one or two of them and elaborate on them. But I think those are, you always want words that you're going to be watching out for, and transfer is a big one. I think that's a really good point.
And I guess the other thing here is you talked about contracts with an offer and acceptance. When somebody sends you this license agreement that they want you to sign, I think that especially most young artists don't realize that this is a negotiation. This isn't that you don't have to sign this or lose it. You can scratch things off of this agreement and write in what you want it to say. That doesn't
absolutely.
That means that you are actually making a counter offer. When he talked about you don't counter offers versus acceptance, you do not have to take exactly what they send you. And in fact, you shouldn't. You should scratch off where it says transfer of rights and write in grant of rights and put in the language that you want. You are perfectly allowed to do that.
When I think that's a really important point. When I was a photographer and someone would send me a contract, it really felt all or nothing. It felt like if I didn't sign this thing, then I couldn't have this job. And scratching parts out, modifying things, changing terms, that's absolutely your right. This is a negotiation, as Michael said, right?
It's not only your right, but it's shot. One of the things that constantly surprises me is that most of the companies, the people from those companies that send you these license agreements don't know what they say, and they don't know what they mean either. And so they're quite often unaware of the extent to which they're asking you to give up so much. So they're more than likely going to be willing to listen and to negotiate with you.
And that leads into something we're not going to talk about today, but I think it's critical. And that's part of your job as an artist is client education. A client may come to you and want a worldwide perpetual rights in every media, that may ever exist or will exist, right? And it's your job to say, look, what you need, what you're looking for is X, Y, and Z, and I'll license X, Y, and Z to you for X dollars. But if you want everything that you just wrote in that thing, it's going to be 100 times what the other thing is, right? You have to educate your client as to what a license should look like, because as Michael said, most people don't know, right? So building on something that Michael said, avoid the pressure to sign an agreement that doesn't have clear licensing language. Licensing language is a big flashpoint for disputes. Make sure that the language in a license allows for the copyright to be retained by the creative. That's exactly what Michael was saying. Only a license, not copyright ownership, when we're talking about usage, reproduction, derivative rights, or display rights. Imagine you enter into a license and you say, you, client, have the exclusive right to put this on social media and the web for the next year. And in your head, you're thinking, well, they're going to be the only clothing company that's going to do that. But then you put it on your website and they say, hey, this says I'm the only one that's allowed to do that. And you're like, look, I created it. It's in my portfolio. I get to show it around. They're like, no, not online, you don't. because you license the exclusive right to me to do X, Y, and Z. If you give your copyright away in a different setting, if you give or transfer your copyright away, then you can't do anything with these rights that we've talked about. So you always want to make sure you carve out things. And I'm going to show you an actual example of what that looks like. Now, I'm going to take a little sidetrack and not go too far down a rabbit hole. And I'm going to talk about works made for hire. And I'm going to tie it back into licensing because I think it's important. You have to know the question, is this a work made for hire? Remember, I said the general rule is that the minute you create the work, you are the owner of the work. You own the copyright, full stop. But there's one exception to that. And the exception is this idea of a work made for hire. And if you ever see anything in your license agreement or your contract or anything talking about works made for hire, first of all, you need to be really aware of what's going on. And second, it's generally a bad thing for artists. Not always, but generally a bad thing. What a work made for hire means is that the author, the person who created it, you, the artist, is not and never was the owner of the copyright, even though you created it. The ownership is conferred to someone else the minute that it's created. Now, how do you know if you're in a work for hire scenario? Well, there's only two scenarios that this could be. The first is kind of straightforward. If you're an employee of an employer, right, and the work that you've created is prepared in the scope of your employment, then it is likely that you do not own the copyright in your work unless you have an agreement that says otherwise, okay? So imagine you work for a school and you're a photographer and you use your school camera and part of your job is to go take pictures of sporting events. And you say, well, I took all these pictures. I did all this work. These are my copyrights. Tom told me the minute I press the shutter, I own a copyright. But that was done in the scope of your employment, and you're an employee. You don't own that copyright. Your employer does, unless you have something written in a different way. But most artists might not deal with that. Most artists might deal with scenario two. And scenario two is where you're an independent contractor or you've been commissioned to do something. If a work is specially ordered or commissioned for use and falls into one of the random 9 categories on the right-hand side, and I'll buzz through those quickly, then, and there is a signed writing that the parties expressly agree that the work is a work made for hire, in that case, also, you don't own the copyright, someone else does. Now, what are those 9 categories? I really don't want you to worry about most of them, like an atlas, maybe, well, okay, maybe y'all are making atlases. I don't know the plural. But the point is contribution to collective work in audiovisual work, part of a compilation. These are things that we often see where you can shoehorn arts into. Those are the 2 scenarios that something can be a work made for hire. Now, this is just talking about what we just said. If you're in the employer-employee relationship, you don't own the copyright if it's created in the scope of your work. If you're an independent contractor, the only way it's a work made for hire is if it falls into one of those 9 categories and it's signed in a written instrument. And now you may be saying, well, I would never sign that. But imagine you get a 10-page contract and there's a clause in there that in 1 or 2 lines says, this work is considered a work made for hire under section 107 of the copyright, title 17 of the copyright, right? And you just say, oh, okay, I'll just sign the thing because they're offering me a lot of money. Be on the lookout for anything that says work made for hire or anything that says a transfer of rights, as Michael was saying. Those are important pieces. Now, last thing on work made for hire. Why do I care about this? You cannot license something you don't own. So if you try to license a picture that is actually subject to a work made for hire type situation, you're then trying to sell something that you don't own. I can't go downtown and grab a car that I don't own and rent it out to someone else, right? I would get in trouble for that. if you're in a work made for hire situation and you don't own the copyright, well, then you can't grant that right to anyone else. You can't license that right to anyone else. Okay, quickly look at some tips and then some examples. All right. Okay. Tips for drafting licenses. Now, as Michael said, a lot of times licenses are going to come to you. One thing I really recommend is that when someone sends you a license, you save it and you look through it and you pick out pieces that you like and you start building your own license, right? So that you know what you're looking for. Every time someone sends you a contract or a license is an opportunity to increase your contract toolbox so that you kind of know what's going on and then you can start writing license. My first question when I work with the client is, what do you want? Is the point of this to have control over the artwork in the future? Is it to just make a lot of money? Is it to have residuals and royalties? Let's say you have been approached by a t-shirt manufacturer and they want to put your art on a t-shirt. Do you want to get $10,000 up front, or do you want to get $5,000 plus $1 for every shirt that's sold, right? These are different things you can put into a license agreement. So first, identify what you're most interested in. Most of the trouble in license agreements and disputes happen when someone does something that isn't spelled out in a license, and each side thinks that one side thinks they're allowed to do and the other side thinks they weren't, and you go back and look at the license really isn't clear. So the more specific you can get in licensing, the better. Remember, as we've talked about, that you need to be able to use the work as well. You almost never want to just sell your copyright entirely. Now, you're in business. Remember, I started literally slide one was you're a business. If someone wants to give you a ton of money to buy the copyright to a work, you can do that. I've sold many copyrights in my life because I was in business, okay, and it made sense. But if you grant an exclusive license, you should generally pair it, carving out, specifically noting that you get to use it for your promotion and publicity. So even if you grant a very broad, exclusive, perpetual license, you should have some language in there that says you retain the right to use it for your promotion and publicity, which means in your portfolio, on your website, on your social media, etc.
So that's kind of an interesting converse to what we've been talking about. You're then selling your copyright, but including a license back to yourself to use it. So you're licensing yourself to use that thing which you create.
100%. If you sell a copyright and you have a clause in there that essentially says you get to retain the use for it, what you're really doing is you're saying you're buying it and you get everything, but you're granting me a license to use it on my website, and we're all in agreement about that. I don't know why those little legal things get me so excited, but I really love that idea, right? I think that's really elegant, and that's things that you can do when you own the work. Okay. Couple example provisions to retain copyright. Here's a quote. All rights not explicitly granted in this agreement are reserved to the licensor. Remember, that's you. Licensor is and will remain the sole and exclusive owner of the copyright and all other rights in and to the licensed content. So what this is saying is, unless the contract, the license specifically grants it, then you own it, right? You retain all the rights, and in particular, the copyright. Now, Michael brought up another great point, which is credit. You absolutely can have something in there that says they have to provide credit. So here's a quote. If the licensed content is used editorially, and now we're talking about not advertising, but like in a magazine, newspaper, and editorial arena, which, let's say it's illustrating an article in a in-flight magazine. Let's say there's 100 examples of editorial. Credit shall be provided as follows, and then you put in however you want credit to read. It is understood that licensed content used for advertising purposes does not require credit. Generally, that's an industry standard, right? And in most areas, is that if a company is buying or licensing your work for an advertisement, they don't have to put your credit, but if it's being used in different scenarios like editorial, then they do. Here are a couple examples These are actually from the document library over at ASMP. So the very beginning, license, section 1, section 1.1, grant of rights. Subject to the terms, the photographer grants to the client a non-exclusive, non-transferable, non-sublicensable. Remember, we talked about assignments and transfers. Sublicensable means, can the person you license it to someone else? We generally don't like that. To display the work on social media, this is a social media specific license, for a period of however long. Such display is limited to one post on Instagram, one TikTok background, one Facebook profile picture, or anything you want to use on Facebook, anything you want to use in any social media channel. You get to put in what the specifics are. The yellow highlights mean you put in your specific information for purposes of a promotion of a music event. The work is defined, and then you describe what the work is, right? What are the image files and the titles and that kind of thing. Talks about third-party rights. Nothing in the agreement will be deemed to grant by photographer or license, sublicense, or other grant of right to a client to use any third-party rights or any rights that cannot be blah, blah, blah. These are legal things, but you might see some of these things in your agreements. Now, skipping ahead, and I'm just going to go through 2 or 3 of these. I'm not going to go through a whole license agreement. But copyright notices, notwithstanding any other provision, client shall ensure that the use of the work is marked with the appropriate copyright notice specified by the photographer in a reasonably prominent position in the order and manner provided. Now, if I send that clause to Coca-Cola, their lawyers are going to cross that out and send it back to me, because Coke isn't going to say that they're going to agree to use my copyright symbol and information in a prominent position, right, in their advertising. But that's okay. Let's put it in there if it's something that's important to you. Like Michael is saying, it can help your case a lot of the time. Payment as consideration. Remember, consideration, there's that word that we talk about in contracts. As consideration for the full rights, client shall pay a photographer a one-time fee of X upon execution of the agreement. Ownership and protection, which we kind of looked at before. Term and termination. A term commences on this day and it ends on that day. And then what happens when it ends? And then assignment. Client shall not assign any of its rights or delegates its obligations without prior written consent of the photographer. It's not that we want to prohibit these things unilaterally. A lot of times we want to just have people ask, right? And when they ask, you can say, sure, you can assign this and you have to pay me more dollars to do it. Remember, you're a business. And then that was a social media license. Here's one that's more general. So subject to the terms, you grant to the client an exclusive or non-exclusive license in the state of, the country of, wherever you're allowing the work to be used, solely to what? Reproduce, perform, display, transmit, distribute, create derivative works. Those are all the categories of things that you own when you own a copyright. Of the work, through what medium and what social media account and what's the purpose, and here's what the work is. So all the things we talked about in our license agreements, the license agreements that I'll generally write for artists are like 2 to 3 pages, but you see this is section 1.1. This is right at the top. We want the important stuff at the top. Okay. Now, I know we have a question or two, but I'm going to jump to that, but thank you. We literally 1 hour's time, we covered a lot of information about contracts and licenses, and we certainly thank you. Thank you for attending, and we hope that you learned something. So let's answer, we have one question here. It says, we're at the mercy of Instagram and Facebook when sharing your work online when accepting their terms of use. Any new changes having creators retaining more control on those platforms? Oh, this is something I could talk about for a while. And there are, here's where I'll start, and then we'll see if we go much deeper. You really can't change too many of the terms. You can't change any of the terms that Facebook or Instagram are going to tell you, and when you agree to use the platform, you agree to what they have. Now, the interpretation of that can get really dicey. I'm involved in a case, and this is a case I'm an expert witness in. It's called McGuckin versus Newsweek. And the question here revolves around an Instagram photo. And the photographer, Elliot McGuckin, put a photo on Instagram, and the photograph was then used by a publication. And the question was, did Instagram give a license to the publication by the fact that the photographer used Instagram? So was Instagram giving a license? Now, here's something really interesting without getting in the details of that case. Instagram came out based on another case and said, it is not our position or our policy that we are allowed to grant third-party rights to people and sublicense work without that party getting permission from the original creator. That's nice that they said that, but their terms of service are very murky, because
doesn't make any difference what they say. It makes a difference what they wrote.
Exactly right. And what they write is that by using the platform, you grant them a sublicensable right to do stuff, so they could do that. Now the question is, can a publication take that and use it? And let me tell you, just because there's like 5 cases related to this ongoing, it's all kind of up in the air. Some courts have found one way and some courts have found another way. What I say to clients and members is this: if you are a visual creator, if you are any kind of creator, you have to be where your clients are, and your clients and your buyers are on social media. So if you say to yourself, I am never going to use social media, that is probably not a winning business strategy. So there are things you can do, like you can have copyright, you can have watermarks and copyright things on your work, which I never liked, and I'm not necessarily recommending that, but it's an option. You can track your work through different services to see where it's being used. You can do reverse image searches, and you can make people try to license stuff. But just because you put it online, on social media, that doesn't give anyone the right who's not Instagram or Facebook to come and take that work and use it how they want to. That's an infringement of your copyright, even though it went through a social media platform. So getting back to the original question, the terms of use are something that it's a David and Goliath thing. At ASMP, I was working with Facebook's lawyers a few months ago on Instagram related terms of use and this embedding idea. What does embedding mean in this whole situation? And these are interesting questions. If someone uses the embedding feature, it means something different than if someone takes a screenshot and uses it, even if it's used in the exact same way. Be aware of the terms of use, but my opinion is don't get too bogged down in the terms of use. You really don't have a choice.
And it's also frustrating because you've got these words. And what happens when you go to court, when you have to sue, you think somebody is taking work improperly? What the court is doing is trying to decide what it thinks the words in the contract mean. And so one of the things that I think probably would frustrate a lot of people is that different courts have come down and said that they mean different things. So the last I understood, if one of these lawsuits was happening in New York, you would be more likely to win as the artist. But if you happen to be bringing the same lawsuit in California, you would be more likely to lose. Under the same set of facts, the courts in New York would rule very differently from the courts in California. So it kind of matters. I mean, like I said, it's frustrating where you bring the lawsuit. So that's one of the reasons you need a lawyer that knows what they're doing is, if you're going to sue, where you do it.
Yeah, and Michael hit on something huge, which is Texas has a different philosophical viewpoint on artist and creator rights than some of the other states that deal with these issues. And in the law, we look at these circuit courts, the Fifth Circuit and the Second Circuit. These are the appeals courts, right? And some circuit courts are more creator friendly and some are less, and that can be really tricky. But the number one thing you can do to protect your work, no matter what we're talking about, is register your copyrights. register your copyrights. And we certainly do that. We've done classes on that at Arts Counsel Texas, and you can go to asnp.org and watch a very long video that I've done on that. And it's an important piece. So, all right.
I say that at every single Lunch and Learn. Register your copyrights. It's the most
register your
important
copyrights. Now, as I mentioned at the beginning, I have the honor and the privilege here in about 20 minutes time to have a one-on-one conversation with the Register of Copyright, Shira Perlmutter. I'm very excited about that. And I am going to bring up to her a number of things, including the fact that registering copyrights is an arduous and difficult task, and it needs to be made easier and less expensive for all artists and creators. And part of my job now is advocacy, and I'm going to advocate for all of you. So we're going to do that here in a minute. And thank you for attending. And Matt, I'll turn it back over to you for some final words.
Thank you all so much for coming out today to this Lunch and Learn. And thank you to Tom and Michael from Arts Counsel Texas for giving us this great program. I know I learned a lot. I also learned that I want to be an at-lie manufacturer, which is something I never knew about. But thank you all so much. If you are interested in coming to programs like this in the future, please make sure to follow us on Instagram and Facebook. We are at Cedars Union. You can also check out at cedarsunion.org. You can look at our calendar to check out upcoming events. And we do one of these Lunch and Learns every month. So if you're interested in additional arts-related legal understandings, please come out to the next one. But thank you all so much for coming today.